Hello, everybody, and thank you for joining us for today's webinar. My name is Sarah Sarr. I'm the Executive Director of MSPA-Americas, and today is our legislative update. Our speakers today will be Paul Ryan, Russell Hollera, and Patrick Hollera. If at any time during the webinar you have questions, you may type those into the Q&A box, which will appear at the bottom of your screen. We will take time at the end of the webinar to answer all of the questions that we have in the queue. At this time, I'll go ahead and turn the microphone over to Paul Ryan.
Thank you, Sarah. Thank you, everybody, for joining us today on the strategies for dealing with the ABC test. A couple of things to go over just prior to Russ and Patrick diving into the actual presentation. You're probably aware we've been working on harmonizing the testing for the federal government over the last couple of years. We have fly-ins pretty consistently trying to accomplish that. In an update in that regards is, along the lines of what's going on out in California, which is going to be the focus of today's presentation, they're also doing some things at the federal level. There have now been bills introduced in both the Senate and in the House trying to get the ABC test put into place as well. This is, of course, what we've been trying to prevent from happening through our harmonization push and with the fly-ins. So really looking for your support moving forward on the fly-ins on the national level. There's, as I said, bills in both the Senate and the House. They're referring to it as a PRO Act. It's probably got quite a few sponsors in the House given the Democratic control there. So your support would be greatly appreciated at a national level. Also wanted to touch base on a state level that most of the state houses have completed their governing or their legislative sessions, but there are still some in business. But we have moved from the ABC test to the common law test in 3 states, and I don't want to steal Patrick and Russ's thunder on this. They'll deal with that in a little bit more detail. But with most of the state houses being, their legislative sessions being over for the year, we're going to be targeting more states next year. And again, Russ and Patrick will talk to that as well. That's kind of a general overall view of where we are right now. Your support, both at the state levels and the national level, is actually greatly appreciated and something that I think we all need to be cognizant of and aware that things like this are popping up, and we have had success in defending against these things. But again, I'll let Russ and Patrick talk to that more specifically. So without further ado, I'm going to hand this over to Russ, and he can kind of take it from there. Thanks, everybody.
Well, thank you, Paul. And before we begin, I'd just like to give just a general disclaimer that today's presentation is provided just as a means to offer some general information on behalf of MSPA-Americas, but it is not intended to constitute legal advice, and there is no attorney-client relationship created by participating in this webinar. With that out of the way, I'd like to move right into the content, and to first provide a little context in which to discuss, as Paul mentioned, this ABC test. I think to appreciate the context, I think just think of all the federal, state, and increasingly nowadays county and city ordinances or laws that are enacted that apply to the work relationship between an employer and an employee. In each of these specific state, federal, or local statutes, an important issue is, if the provision applies to an employee, who actually is an employee? How can you tell if an individual is covered by these laws? And over time, there are 3 tests really have evolved, some through court decisions, some through the statutory enactments themselves. And those are essentially the common law test, the economic realities test, and what we'll be talking about today, the ABC test. Now, the common law test is probably the most prevalent test of all. It's the test that will be applied, for example, if you have a worker status dispute before the IRS, say on the National Labor Relations Act and ERISA, they all apply essentially to the common law test. The economic realities test is a test kind of out by itself, and its application is limited principally to the Fair Labor Standards Act that imposes a duty on an employer with respect to an employee with respect to matters such as overtime, minimum wage, record keeping, and that sort of thing. And there are a few other statutes that are derivatives of the FLSA, but kind of a small category of statutes that apply this economic realities test. And then the ABC test is a test that's found most predominantly in the state unemployment tax statutes, with a few exceptions. And as Paul mentioned, California recently adopted this ABC test, but it did so in a very unprecedented manner, because in most states, the ABC test is a statutory test, meaning that the state legislature, for example, in enacting the state unemployment provisions, it provided by statute that to create an independent contractor relationship that would not be covered by state unemployment taxes, the relationship needs to satisfy these three factors. It was unprecedented that out in California, what happened, by contrast, a court decided to adopt this ABC test to define employee status. But then in terms of the ABC test itself, there are a few, I think, important aspects to focus on. And we'll be discussing these later throughout the presentation, but what's on the screen now is kind of a generic, typical ABC test. Again, the three factors, but what's important is the key terms are highlighted in red to focus on. It's essentially, and again, to create an independent contractor relationship under an ABC test, you need to satisfy each of those three factors. But separate from that, many statutes provide along the lines of what this initial paragraph states, which is an individual performing services for a given company in exchange for pay is deemed an employee unless, again, the three factors are satisfied. But it's important to focus on that language. It applies to individuals who perform services for a given company. And then you move on to the ABC factors. The A factor is essentially the common law test. And it's applied, the classic right of control. Do you control the means or methods of performance? Under the common law test, if the answer is yes, you have an employment relationship. If the answer is no, it's an independent contractor relationship. What's important to focus on here with the A factor, though, it's essentially the right of control first, and secondly, it's in fact and under contract. So you need to make sure that not only do you operate in a manner in which you don't control the means or methods of a mystery shopper's performance, but also it's essential that you make sure that your contract itself is very clear that it doesn't reserve any right to your company to control the means or methods of performance. If you fail in either of those, you will not satisfy the A factor. The B factor, the second factor, most states have two ways to satisfy it. The first way is to show that the services performed by, in your case, the mystery shoppers, are outside the usual course of your company's business. The second way is to show that the services provided by mystery shoppers are performed outside of all places of business of your company. Now, this second one, you think viscerally, well, of course we satisfy that, but as we'll talk about later, courts have construed that to be a little narrower than you would expect. And then the third factor, the C factor, you need to show that the mystery shopper, in this case, is customarily engaged in an independently established trade or business. So that's the overview of the test. Now, one way to think about the ABC test, really all the factors are interrelated, because if you look at, for example, the IRS has a 20-factor iteration of a common law test. And within those 20 factors, you'll find the B and the C factor. So the B and C factors are really considered as part of a general common law test. What distinguishes an ABC test from a common law test, however, is that the B and C factors are deemed to be mandatory factors as opposed to just one of the many factors that are considered. Also be aware, when people refer to an ABC test, there are really a lot of different varieties of the ABC test. And in some cases, there's an AB test, again, the two factors instead of three. And one important different permutation that you'll find among the B factor is one's a two-pronged factor, one's the one-pronged factor. The two-pronged factor is what we discussed earlier. you could satisfy the B factor in either of two ways. Either the services are performed outside of the course of business of your company or outside of all the places of businesses of your company. Some states, though, do not include that, and they have only the one-pronged B factor, which is that you need to show that the services that the mystery shopper performs are outside the course of business of your company. And two states that have that, one is the California, that's the version California adopted, and also that's the version that was enacted by the legislature in Massachusetts. In fact, when the court adopted this test, it explicitly incorporated the Massachusetts version of the test. And just so you know, the Massachusetts version is the most difficult of all to satisfy. It's the most demanding version of the ABC test that's out there. So where will you find the ABC test? You'll find it, again, predominantly in state unemployment tax statutes. In some cases, there's like a bona fide, just say worker misclassification statute that asserts penalties for just misclassification. That's an example is Illinois. And then sometimes you'll find it with respect to employment laws, example of California, Illinois, and New Jersey. Now, in terms of how to satisfy this test, one thing I'll say at the outset is that I know the ABC test, especially in light of what's happened in California, it's attracted a lot of media attention. And a lot of the articles that you might read about the ABC test might lead you to believe that it is impossible to satisfy the ABC test, that it is the death knell for independent contractor status. What I can tell you is that is affirmatively not true. I mean, if you look at the reported court decisions in states like Illinois, Massachusetts, you will find that there are plenty of companies that have actually litigated the issue under an ABC test and have won, where the courts have said, yes, you meet all three factors of the ABC test. Patrick and I have been involved in state unemployment tax disputes under an ABC test and have prevailed. We've been able to demonstrate that, yes, the company satisfied the ABC test. So it is satisfiable, but in order to maximize your chances of satisfying the test, it's critically important that you be mindful of these factors and try to structure your business and operate your business accordingly. Okay. So with that, as I mentioned, one of the threshold requirements in many ABC tests is that it applies only, essentially I shouldn't say apply, that an individual will be subject to whatever the statute is only if you make the threshold finding that that independent contractor provides services for the company and is paid remuneration by the company. And if you don't show that, you don't even get to the ABC test. So what we found, in fact, there have been instances where, for example, we had a case in Georgia where under the ABC test, could they meet the test? Well, it was uncertain, but we were able to demonstrate that the individuals at issue provided no services for the company and they were paid by the client, not by the company. And the administrative law judge held that these people are not independent, are not covered by the statute because they don't meet the threshold test. And so a way is you could strengthen your ability to make this argument. And again, it was a different industry, but the other industry operated under what, in my view, fundamentally the same business model that's operated in your industry. That is, you have one company contracts with the independent contractors, and those contractors provide services not for the company, but for third-party clients. So one option to try to bolster your ability to make this argument is to consider setting up an escrow account, just a separate bank account. And what it is, it's a bank account through which client payments travel from the client to the escrow account to the independent contractors. What that does, that gives you the ability to make the argument that, first of all, when we contract with the mystery shoppers, we contract with them to provide services for who? Not us, our clients. Secondly, make the argument that when mystery shoppers are paid, they're paid by the clients, not by us. And in fact, the clients pay the mystery shoppers through this escrow account we maintain, through which the clients pay the mystery shoppers. So again, that's one possible strategy for bolstering your ability to defend against an ABC test. And there are other states like Arizona will follow, for example, a federal tax determination. So for example, if you've been audited by the IRS and IRS has determined that you qualify for Section 530 protection, that might protect you against potential unemployment tax liabilities in Arizona, regardless of the test. So again, depending upon the state, some states have unique statutes that allow you to satisfy the test, even if you can't meet, for example, the ABC test. There are different ways you can still satisfy or establish the mystery shoppers as independent contractors. One other thing I'd like to just mention, just somewhat in this context, is nowadays, you might also read in the popular press about companies getting sued in these class action lawsuits. They're claiming their entitlement to some type of protection under a federal or state employment law, and they bring a lawsuit in the form of a class action lawsuit. One very effective means for mitigating your risk to a class action lawsuit is to include in your independent contractor agreements an arbitration provision that prohibits class-based claims. So it provides essentially, if there's a dispute between the independent contractor and the company, that dispute shall be resolved through arbitration, and those disputes will be resolved on a one-by-one basis. Neither party can bring other class members and make it a class action type resolution. The U.S. Supreme Court has affirmatively endorsed the use of these provisions, and again, they have historically been very effective in mitigating your exposure to class-based claims. Now we'll move to some specific ideas on how to satisfy the substantive requirements of the ABC test, starting with the A factor. Now again, the A factor is just the control test. And as you probably know, this industry has been remarkably successful in defending the independent contractor relationship under the common law test. I mean, we've represented a variety of companies in this industry and have successfully defended the model under the ABC test. Others have as well. And there's plenty of court decisions out there showing companies routinely can satisfy this test. But again, you got to be careful. You need to be proactive and make sure you have your company set up so that it can satisfy this test. As I mentioned earlier, you need to look at both the day-to-day operations and the contracts. Now, one rule that's somewhat helpful, I think, in this industry is that courts generally follow the proposition that control exercised by a third party is not imputed to you unless they do that as an agent of yours. So, for example, look at the diagram. If you have a client, for example, that exercises some degree of control over the independent contractor, that is not imputed to you. So that can't deem you to be the employer. Now, it might create exposure to the client, but not you. And likewise, I mean, by contrast, though, that if you have an agent, someone operating on your behalf that exercises control, well, that will be imputed to you, and that will be taken into account. So I guess a practical application of this is that, say, for example, when you have your clients who describe what they want done in a mystery shop, so long as you keep yourself detached from that, that should not undercut your independent contractor relationship with a mystery shopper, because you have nothing to do with that. The client is a third party, and that whatever the client requires is not imputed to you. So other things to keep in mind are, as a general rule, you should not retain a right to terminate a mystery shopper while the shopper is performing a client evaluation. The right to terminate is a classic indication of an employment relationship. You want to try to avoid having anything in your contract giving you a right to terminate, for example, if you're not happy with the performance or anything like that. Likewise, I just said a minute ago about these client descriptions of the project. As a general rule, I'd recommend that those descriptions, it's okay if they have the client logo, but they should not be co-branded with your company's logo. Because if you co-brand it with your company, all of a sudden, you both are imposing whatever the duties are. Whatever is in that document is imputed to you. And generally, you don't want that. You want to keep yourself as detached from that as you can. In addition, with respect to finding mystery shoppers for a specific engagement, ideally, you do not want to be selecting specific mystery shoppers for specific client opportunities. It's much better to offer them to multiple shoppers and then allow them to accept the opportunity. Because, and again, the rationale for this is there's a perception that if you're selecting specific shoppers for specific engagements, then you're exercising a lot of control over their destiny, because then there's a perception that they need to essentially kind of keep you happy in order for you to select them for a shop, and that's again viewed as an evidence of a right of control. Now, say finally, it can be helpful to utilize these third-party scheduling firms or website platforms, because what that does, again, it creates a third-party kind of separation between you and kind of the selecting of mystery shoppers to perform the engagements. So that can be helpful in terms of, again, detaching you from that decision. Also, in the independent contractor world generally, terminology is critically important. I cannot tell you how often, and again, our focus really is the issue. We work on the independent contractor issue in a variety of different industries, and I cannot tell you how many times we've come across documents where just the name themselves, they're like an employment agreement or just the word employee throughout. What happens sometimes, people get documents from other people or whatever, other companies, and they use them. Never do that, never do that. You want to make sure your contracts are very expressly intended for independent contractors. And even in your overall communications, for example, there's no payroll, there's no employment application. And something else to watch out for is possessive references to independent contractors. They're not our mystery shoppers. When you say there are mystery shoppers, I mean, you can see what that suggests in the ears of the audience. I mean, that's a problem, because you want to be detached. The independent contractors, they operate their own business. You operate your business. They have their business. They are not yours, just as you are not theirs. Also, it is always good, as best you can, to define objectives, to describe what a project is in terms of objectives. Sometimes you'll see, for example, the client objectives described as instructions or things like that. You're just undercutting yourself. They are not instructions. Instructions, again, that's a code word, classic employment characterization. Characterization. It's a, you define an objective for independent contractors. They decide how to accomplish that objective. You don't instruct them on how to do it. It's also important to allow independent contractors to accept or reject opportunities. Let them determine which ones to accept. Thereby, they're determining when, where, and how they work, because they're exercising that right through their ability to select which shops to perform. If possible, I don't know how feasible this is, but if possible, try to allow some degree of negotiation with respect to project fees. I mean, I know that's difficult with a large number of opportunities, but to the extent it's feasible, it'd be nice, because that's a hallmark of independent contractor status as well. Contractors are viewed as having a right to negotiate their fees to some degree. If it's all take it or leave it, that somewhat counts against you. It doesn't mean you can't win, but it's a factor that to the extent you can show negotiation, it's helpful. And finally, to the extent that you've ever been involved in a state unemployment dispute and lost, sometimes I've heard of states telling a state telling a company, now that you owe state unemployment taxes, you shall report those earnings on a W-2. That is patently false information. A state has no jurisdiction over IRS forms. So even if you lose in a state, there are some states that are very difficult to win in. If you lose in that state and the state tells you to, going forward, report those contractors on a W-2, do not do it. Continue reporting them on a 1099 unless you feel like they are in fact employees for federal tax purposes, but the state has no authority to get into that. So again, some classic things to avoid, with respect to independent contractors, again, they operate their own business. So what you do not do, you don't train them, you don't instruct them, you don't monitor them. You want to avoid anything like evaluations, things of that nature that's viewed as, again, a control type activity. You can evaluate outcomes, yes, but not how they accomplish those outcomes. And you also want to avoid things like periodic meetings or requiring reports on kind of progress. All those are classic employment type characteristics. Likewise, you really don't want to be on site when a mystery shopper is performing their services, and something you want to certainly not have are any kind of documents like policies, procedures, handbooks, any of that nature that kind of describe how to perform a mystery shop. that, because what that's viewed as kind of evidence that you're instructing them on how you want them to perform the services, which again is a classic employer-employee type function. And I have to say, I mean, you would think you never see these, but you do see these. But you want to the extent you have any of these things, I would discontinue their use, because they can only be used against you. Any kind of non-compete provisions, restrictions on mystery shoppers' ability to obtain clients through others, those can be deadly to an independent contractor relationship. In this industry, you don't really need them, and if you have anything like this in your agreement, you ought to delete them. And then finally, ideally, a project-based fee is far superior to an hourly rate for independent contractors. So, for example, if you have a choice on a project, you could define it, say you anticipate it being like, say, a 3-hour project, and you think, well, okay, it's for example, a $10 rate, 3 hours, you could charge that, you could characterize it as an hourly project, $10 an hour, or you could characterize it as a $30 project fee. As between the two, the $30 project fee is immensely better for defending the independent contractor status as opposed to an hourly rate. So to the extent you have any discretion, always go in favor of the project fee as opposed to an hourly rate. Some of the classic prohibitions, you really do not want to reimburse a mystery shopper for out-of-pocket expenses. Now, this industry, it's okay to disperse those reimbursement items that the client provides. But again, you're functioning as a conduit. It's not you, it's the client. Again, that can't be used against you. Something else that's important is trying to avoid provisions in your contract that prohibit an independent contractor from hiring assistants or subcontractors. It's okay to require them to let you know if they're doing so, just so you can make sure that your clients don't want the same shopper going to the same location time and time again. So in order to protect against that risk, it's okay to ask them to let you know, but you do not want to have just a blanket prohibition against hiring assistants or subcontracting. That is a factor that affirmatively is attached significant weight and will be used against you. And as we already discussed, you never want to have a right to terminate a contract except upon a clearly identified breach. Because again, a right to terminate for any reason is viewed as like an employment at will employment relationship. And it's also viewed as a way you can exercise control over a person, because you can, the perception is that you have this threat of terminating unless they do it your way. So you don't want that. You don't want that. And then finally, some of the others are, you don't want to have the independent contractors wear anything identifying your company. And likewise, no geographic restrictions. It's a sign of control. And ideally, you don't want to provide, say, employee benefits or workers' comp coverage to the independent contractors. Likewise, you don't want to require them to accept any kind of minimum number of projects. And also, you don't want to allow your office employees to perform mystery shops. Because you can think about that. I mean, if the problem that arises there is if you have employees doing the exact same thing as mystery shoppers, then you're in the dilemma. Well, they say, well, if they're doing the exact same thing, why do you call these people employees and those people as independent contractors? Plus, from a different context, a federal employment tax context, that can undercut your ability to claim a classic safe harbor protection. So generally, you never want to allow your office employees to perform mystery shops. Very inadvisable for a host of reasons. And then finally, just in a global sense, sometimes I see, like in agreements, it seems like there just be certain requirements that are imposed just for no reason, because you can. Generally, you want to delete those, strip them out, because they'll only be used against you. And also, in any kind of materials you give out to the independent contractors, including the contract, try to avoid words like shall, must. You shall do this, you must do this. Because again, what's the perception? The perception is you're exercising control. So just in a global sense, you want to try to stay away from things like that, because they can be used against you in certain contexts. So what do? I mean, I think to do an internal review for the A factor, things to check are kind of essentially any kind of documents you have that an independent contractor would see, or that a client would see, or that the public would see. You just want to make sure that everything that is outwardly facing is consistent with the model. And likewise, your internal policies and procedures should also be consistent with that. Things such as if you have like a position description for the people who interact with the independent contractors, it'd be advisable to have in that position description for your office employee, something to the effect of, respect their independent contractor status. You don't require them to do, you can't require them to do things. You just have, a position description that recognizes the independent contractor status of the mystery shoppers. Next, what's really been vexing for a lot of companies is this B factor of the ABC test. And I think a way to think about this is through, one of the years ago, the Venn diagrams. Okay, the goal you want to achieve is the top set of diagrams. You have the company's business, you have the IC's services. They do not touch. In fact, they're clearly detached from each other. What you want to avoid is your business and the independent contractor's services having overlap, because you want to be able to demonstrate that the services of the independent contractors are outside the usual course of your business. Now, courts have found that a company can have multiple courses of business, and if they're found to provide those services, that's it. So how do you define, how do you figure out what is a company's course of business? Well, probably the most reliable indication, according to the courts, is how a company self-describes its own business. So if you describe your business as providing X, well, the courts will assume that, well, X is what you provide. So in our context, I think what you do not want to do is describe your business as providing mystery shopping services. Because if you do, it's very difficult to argue that the services provided by the mystery shoppers are outside the course of your business, in as much as your business is providing mystery shopping services. You can see it's a trap out of which you cannot escape. So what do you do? In my view, our view really, there are really two fundamental models you can operate in this industry, I think, and satisfy this B factor. The first is just be a broker, like an Uber or a Lyft, that you're just a broker. What you do, you match independent contractors with clients. That's one option. Option number two is you can be more like a, which I think is actually accurately describes many companies in this industry. You're really more of a kind of a consulting firm with an expertise in the customer experience, and you can help clients, improve their customer experience, and you can also help clients come up with ideas on how to measure that customer experience in order to see if it's getting better or worse or what's happening. And under this second option, what you do, you utilize third-party tools outside of your business to gather the data. And that can include mystery shoppers, could be customer surveys, could be other electronic means nowadays available to gather the data. And what you do, you analyze the data and you make recommendations based on that data. But what you do not do, you're not a data gathering business. So just be very clear in that regard. And some support for that. And by the way, I guess moving to the support, that this court case recognizes the first option, the broker case. The Supreme Court of Nevada looked at that broker model and correctly, in my view, analyzed it and said, look, the broker is a broker. In this case, it was a respiratory technician, but it could be a respiratory technician, could be a mystery shopper, it doesn't matter, that they're two completely separate businesses. And the fact that one relies on the other is irrelevant because the two are separate and distinct. And in this case, the broker was held not to satisfy the B factor relative to the respiratory technicians because they are two very different businesses. So that supports the first alternative. Alternative two, there's, again, court case, an insurance company essentially developed insurance products. That's what it does. It develops insurance products. It has actuaries and it develops insurance products. But it made the decision it does not sell insurance. So you might say, well, how could that be? How could you be an insurance company and not sell insurance? Well, that was their decision. That's what they did. What they do, they outsource the sales to, among other things, independent contractor insurance salespeople. And the court analyzes and said, that's right. A company has the right to define the boundaries of its operations. It chose to only be a developer of insurance products. It chose not to be engaged in selling those products. That's its right. So you apply that to your business. You have the right to define your business as what it is, and you have the right to define the boundary of your business as not including data gathering. But you need to make that very, very clear. So go over some of the factors that courts sort of look at in terms of trying to figure out how a company defines, what is the course of business of a company. Again, the number one issue they look at first is how does a company describe its business? So where do they look for that? They look at your website, your marketing materials, even your agreements. How do you describe what your business is? Another factor taken into account is whether the business is directly dependent on the success of the independent contractor's endeavors. And what this classic scenario here is where, say for example, you have an independent contractor who's operating on like a commission basis, okay, and they're going to split the commission. So then the courts have said, look, you both are in the same business, you're splitting the commission. So what they're doing is absolutely in the course of your business because look, your economic return is directly tied to that independent contractors. So as applied to your business, again, I think it would just be very, again, it's helpful to where, like on the fee issue, where clients pay the mystery shoppers and the client pays you your fee. When you take the position, essentially, we're a broker. Our fate is not dependent upon the success of the mystery shoppers. We match the two. That's what we do. And or if we're a data gatherer, if we're a consulting firm, again, we go out and gather the data. What they do has nothing to do with us because we really analyze the data. We're not in the business of gathering the data. So, our success is not tied to the success of the independent contractors. And likewise, the results. And there they look at, do you do things like train? Do you try to get the mystery shoppers to do things certain ways? If you do, if you're perceived as training and trying to get the mystery shoppers to do things certain ways, there's a perception that the only reason you do that is because they're essentially working for you and that your business is dependent upon what they do. You want them to do it your way because it's your business. So again, you want to stay away from having things like that, training materials or any kind of materials that are instructing mystery shoppers on how it is to do what they are engaged to do. And likewise, again, you want to stay away from doing things that could be in any way perceived by a third party as allowing the independent contractors to be thought of or perceived to be part of your business. The mystery shoppers should not be given logo wear badges or anything that identify your company. Because again, it sends the message to the outside world, they are part of your company. And what they're doing must be part of your company's course of business. So again, you don't want to do that. So again, what do you look at? Kind of like what you would expect. The only couple of things I'd like to point out you might not expect would be articles of incorporation and bylaws. There was a court decision out in Arkansas where a company lost principally because its articles of incorporation defined the company as providing the services of the independent contractors. It was used against it. So again, you want to look at everything, but including even documents like that. But the others, I think, are what you would probably expect. Now I'll move quickly to the second prong of the B factor. That's the place of business. So really the key to this factor is that while you would viscerally think that what this relates to is physically where does the independent contractor provide the work, and since, say, for example, you're located in New York, mystery shopper is performing an engagement in California, how could that possibly be deemed to be a place of your business? Well, what courts have done, they've construed that to mean your place of business includes any location where essentially they're advancing your business interests are being represented. So again, this ties into kind of the first prong of the factor, which is if an independent contractor is perceived as performing services essentially on your behalf as part of your business, then where they are performing those services, in some cases, in some states, will be viewed as an extension of your place of business. So again, a way to protect against that risk is consistent with the first prong of the B factor, just to be very, very careful that you always consistently define your business as what your business is, and that definition clearly detach what your business is from the providing of mystery shopping services. Essentially, the data gathering function that mystery shoppers provide. And that's why, in my view, this the B factor, whether it be a one-prong or two-prong, it's really kind of a super integration factor. Integration really being this, are the services of an independent contractor an integral part of your business? Because they both really look at very similar factors. So with that, again, we didn't cover every bullet point, but we'll be handing out the slides. Just want to kind of give you more of the big picture. We'll move now to just some of the things that you should avoid on the B factor. Okay, again, of course, you don't want to have mystery shoppers being on your premises at all if you can help it. Like picking up materials, et cetera, you'd be much better off to send it to them as opposed to having them come to you. And again, name badges, et cetera. And again, this final thing, describing your business. That is key for all the reasons, really. And then what are some documents that you would take a look at? Again, classic ones: a website, independent contractor agreement, marketing agreement, client agreement, et cetera. So really, with respect to the A and B factors, very similar documents that you'd agree, you would want to review, and then again, just prepare for ensuring that those are satisfied. Now, moving to the C factor, I'll now turn it over to Patrick.
Thank you very much. So this is the final factor in the ABC test, and like the B factor, this factor is also problematic for many companies for a slightly different reason. As we'll see, the reason this is problematic is that a company seldom knows sufficient facts about an individual to determine whether that individual will actually be able to satisfy the C factor. So it really kind of puts a company at a disadvantage when it comes to satisfying this factor. They often don't find out the facts until it's too late. And also, many of these factors are largely beyond the company's control. So at a high level, this C factor, courts really interpret this factor to try to distinguish between, say, an individual who has made the decision to go into business for themselves, operate that separately established trade or business, versus an individual who is very dependent on a company. And one way a court will interpret this. Yes.
This is Sarah. We can only see your desktop. We can't see your PowerPoint.
Oh, I apologize. Thank you very much.
That's okay.
How's that?
There you go. Thank you so much.
Oh, thank you. And I apologize for that. So I'll just go back to the prior slide. It was just the introductory slide. So continuing on, really what courts are looking at in interpreting this factor is, will the individual's business continue in the event the relationship with, say, a client company were to terminate? So for example, if a client company were to go bankrupt, would that independent contractor be able to operate their business notwithstanding that company? Would they be able to find new clients? Would they be able to continue operating? If the answer is no, that's more likely indicative of an employment relationship, would likely fail the C factor. And one other thing that I think is very important to note before we look into this in more detail, just because a company does not prohibit an independent contractor from performing services for say others, that's usually not sufficient. What a company usually needs to establish is that the individual actually is in this separately established business. They're actually conducting a trade or business. In the next few slides, we'll look at some of the factors that courts will evaluate in this phase. So some of these common factors, the first being whether the individual actually performs services for others. Do they have other clients? And in the mystery shopping context, is an independent contractor evaluator registered with multiple MSPA member companies? Are they obtaining evaluations from several different companies? If the answer is yes, well, that would certainly weigh in favor of satisfying the C factor. And one way to think about this is, an employment relationship, an employer would unlikely allow their employee to concurrently provide services for a competitor. And again, independent contractor relationship, that would be encouraged. So some other factors to keep in mind that courts will look at, whether the individual has an office. Are they licensed, independently licensed, and the license being in their own name? And what are they doing to promote their business to the outside world? Do they have business cards? Do they have, say, a website? Are they advertising? Do their invoices have, say, their logo on them as opposed to their client company's logo? Also, has the individual made some type of investment in their business? For example, do they have liability insurance? Are they purchasing vehicles or equipment? And are these vehicles and equipment purchased in their own name? Similarly, does the individual have any employees or some contractors? Are they operating a business here where they can say collect multiple clients and then have use economies of scale and then farm those out to other individuals and really build a business? Similarly, following into that, is there a going concern here? Could this individual actually sell their business? And really, related to that is, can the individual generate a profit or loss? An employee typically cannot generate a profit or loss. They go to work, they receive their payment, that's the end of it. By contrast, an independent contractor, they're in business for themselves. They have revenue, they have expenses. Will that revenue exceed expenses or not? And ways to take into account of that is, are they making expenditures and are they gaining clients? Similarly, along those lines, if you are generating a profit or loss, are you reporting those profit or losses on your federal taxes as a business as opposed to purely for individual purposes? A few other factors are, are any licenses, similarly, is there any equipment, any investments that the individual has made, are they in their own name relative to, say, in a client's name? If they're in their own name, more indicative of an independent contractor relationship. Now, as I mentioned earlier, many of these factors are going to be beyond a company's control, but this final factor here, this is something that a company does have complete control over. That is, does the company itself represent the independent contractors to third parties as independent contractors, or are they represented as employees? This is something you would want to check as you're reviewing those documents that Russ described before. Are you representing these individuals as your employees or as independent contractors that have been separately engaged? So I briefly mentioned this earlier in the beginning of this section. Really, the C factor does just present a significant problem to companies. And really, it's this asymmetry of information problem. When a company engages an independent contractor, they usually do not know whether the independent contractor will be able to satisfy those factors that we just discussed. And frankly, they have no real business reason to know this information. As a mystery shop, as a MSPA member company, your priority is, can this evaluator complete this evaluation? Okay, yes or no? You're not concerned with, do they have other clients? Do they have business cards? So that's not something you're typically looking for. And you usually find this information out after an investigation has commenced or a lawsuit is filed. And as I said, at this point, it's too late. The facts are what they are, and there's really not much that can be done about it. Now, there are, in our opinion, there is a proactive, many proactive strategies. One proactive strategy being this tool that we developed to help eliminate this asymmetry of information as it pertains to this factor. Really, we created a tool for self-employed independent contractors to be able to demonstrate to their clients the steps that they have taken to establish an independent business, essentially to satisfy those factors, and also to document their intentions that they do really want to be self-employed. And as some of you may know, this is a tool we've called Certified SC. And really the background for this is we developed this for a particular client initially to help that client identify independent contractors that would be helpful in a hearing. Essentially identify witnesses that would be supportive of their business model. And we decided that this is probably something that could be helpful to other companies faced with the same problem in an ABC test jurisdiction. So we've now made it available to everyone. And in our opinion, it really does create a win-win for not just independent contractors, but also to client companies. From an independent contractor's perspective, it kind of helps gives them a competitive advantage because they can demonstrate to their clients that not only do they want to be self-employed, but they have taken certain steps that would allow the company to satisfy the C factor. Therefore, these individuals are going to be less likely to do business with. And then from a company's perspective, you can really mitigate your risk relative to the C factor because you would have access to the information that these individuals provide this business, so that you could then put together a relatively robust set of answers to, yes, we can satisfy the C factor for these reasons. These independent contractors have done X, Y, and Z. And so this is a tool that we promoted to shoppers to try to encourage them to participate in this program, not just for their benefit, but also for your benefit as well. We promoted this at ShopperFest last year, and we intend to do so again next week. And just briefly how this operates, we created an industry-specific questionnaire. We have one for mystery shopping industry specifically. This is a questionnaire that the independent contractor annually completes just to keep the information current. And really what's unique about this is the individual agrees that they're not going to dispute their responses and that the responses can be shared with inquiring companies. So in a sense, if your company was subject to an unemployment or audit in one of these ABC test jurisdictions, you could send information over on who the independent contractors that work in that state. If they happen to be a certified independent contractors through us, we could send you their responses, and you could use that to bolster your defense. And the final bullet point there is, again, it could also help you identify those witnesses that could then corroborate that you satisfy the C factor in one of those disputes. And for more information on Certified SE, here on the slide is the website. It's certifiedsc.com. And now bringing it back to the ABC test here, we spoke about the ABC test kind of more at a high level, but here's a list of the states where an ABC test or an AB test is actually applied. So these are those jurisdictions where you would be at risk for having to satisfy either the three factors or the factor or the two factors, the control factor and then the separately established trade or business factor. And this slide will be going out afterwards, so don't feel that you have to take note of those states. And I wanted to finish up here with giving you an update on kind of where we're going with these different states. As you saw, there are about 26 states that currently apply some version of the ABC test, but that number could change. There does seem to be a renewed interest at the state level to change these tests. And the most prominent example I think that everyone's very familiar with right now is in California. That's what this bill, this AB 5, and this is a bill that would codify that ABC test, which was adopted by the California Supreme Court in the Dynamex decision. This would then be adopted for purposes of unemployment and also the California Labor Code. This AB 5, it was introduced at the end of last year, was recently passed by the State Assembly, and has been referred to the Senate. It's now sitting in the Senate Committee on Labor and Public Employment and Retirement. Now, before this bill is enacted, it still needs to be passed by the Senate and does need to be signed by the governor. And while I understand that this AB 5 is alarming, I do want to reassure you that the recent trend is that states are really going the other direction. This is one state trying to go from a common law test to an ABC test, but so far this year, 3 states went the opposite direction. They went from an ABC test to a common law test. And as you see on your screen, those states were Arkansas, Oklahoma, and Tennessee. And I can report that MSPA was very helpful in having these bills enacted. As Paul mentioned earlier in his introduction, the state sessions have largely concluded this year, but we're already getting ready, ramping up to continue this effort next year to flip more states from this ABC test to this common law test. So again, I understand AB 5 is alarming, but there is more promising news than signs of going the opposite direction. So things are, I still think, looking up. And with that, I do want to invite Russ back on the phone and then open it up to any questions we have in the time remaining.
Okay, Russ, are you there? Ready to answer some
yes.
questions? Okay,
Sure.
great. Excuse me, we do have a few that have come in so far. Can you explain what occurred in California, what we need to do to protect our mystery shopping company, and what we need to instruct our shoppers to protect them, as well as reduce our risk for misclassification?
Well, in California, there is the pending bill that Patrick mentioned is not yet law. Now, separate from the bill, for state unemployment taxes, for example, in California currently a common law test is applied. Now that could change if the bill is enacted, but if the bill is not enacted, the common law test would continue to apply. But even if the bill is enacted, again, part of the rationale for our webinar today is the best strategy, we believe, for companies doing business in California with independent contractors is to try to ensure that your business model is set up in such a way that you can defend the independent contractor relationships under the ABC test. Because again, California is not the only state. Even if California were to enact the law, it would just become one of the other existing more than 20 states that also apply some form of an ABC test.
Okay, thank you. We'll move on to the next one. How can we convey the how-tos for a mystery shop if we can't provide any instruction?
Well, now I think that really gets to the essence of the common law test. Because in theory, independent contractors are operating their own business. They're in business to provide a certain type of service. And the reason the company would contract with an independent contractor is because the company wants to engage that person to provide what that person is in the business of doing. So, I mean, in some respects, to say, how can we instruct an individual to learn how to become a mystery shopper? That is something that's really better done through some kind of a third party, for example, MSPA, or some other organization that is in the business of helping individuals become mystery shoppers. That really is something that a company that is contracting with a mystery shopper as an independent contractor should not be doing. Because that's a classic indication of employment status. If you're training someone to do what it is you're hiring them to do, that's what an employer does.
Okay, thank you. How do you close down a corporation to best insulate yourself from personal liability? And which state laws do you say has control of arbitration? The state of California or the state your business is located in, which may not be California? Okay,
now the first question I think is really more of a state law issue that's a little outside the scope of what we're addressing today. In terms of how do you close down your company, that's more of an asset protection issue. But then separately with respect to arbitration, an arbitration agreement is really a contract in which you and the independent contractor agree to how a dispute will be resolved. So you really have discretion to determine the venue, kind of where the arbitration will be conducted, as well as the state law, which state law would govern the resolution of that. Now, also what we recommend with respect to arbitration provisions is that it's really a litigation mitigation technique, and we urge you really ought to work with your litigation lawyer, the lawyer you would use to defend the company. Imagine you get sued in a class action lawsuit. Think about who would you hire to defend the company against that class action lawsuit. That's really the person who should give you the detailed advice on how to structure your arbitration provision. Because again, it's a contract, and there are a lot of elective provisions in there. So you want to have the person who would defend you in the litigation be the one that makes all the decisions in terms of how your arbitration provision should be set up. Because again, it is a contract where you set forth how a dispute will be resolved. So again, that's an issue you want to discuss with the litigation attorney you would hire to defend your company.
Okay. Again, if anybody has questions, you can type those into the Q&A box at the bottom of your screen. We will be making this webinar available through our website, so don't worry if you're not catching all the answers. We'll also have a copy of the slide deck in there, so we'll be sure you have all that information available to you. I will send that out to everybody by end of week once we have all of that available. So don't worry, you will get a copy of it. So one of the questions we just got, Russ says, we don't typically ask about whether our shopper has experience with other companies, as this can raise issues. How are we to know that a shopper is someone who is actually shopping for other companies?
That's the dilemma that Patrick addressed. I mean, one way is if the shopper decides to become certified. But again, that's a decision that the shopper needs to make. Another option in this regard is kind of alluded to earlier, the use of these third-party either scheduling firms or websites. Those also can operate as an effective defense against that, because, you know, say for example, if a person comes through one of these sites or through a scheduling firm, and just so you know, I have no connection with any of these types of firms, but just in terms of defending more of the companies, the ability to argue that, you know, the company does contract with some directly, but they also get some through these third parties. You know, it's a helpful fact to demonstrate a detachment away from them, and also to demonstrate that these people really are actively engaged in their own trade or business, because they've gone to the trouble to register with these third parties whose very business is to try to connect them with other companies that can connect them with clients. But otherwise, that's the dilemma. I mean, how do you know? It's just an opaque line that you just don't know. Now, I guess you could on your independent contractor registration form, you could ask the question. You could ask them to identify or just ask them by numbers. You know, how many other sources do you utilize to obtain access to mystery shopping opportunities? And you can also have something in your independent contractor agreement, wherein the independent contractor represents and warrants that, yes, I am an independent contractor, and I do not intend to rely solely on you as my sole source for gaining access to client opportunities, because I'm using it solely to supplement my client base. So you can do things like that, but otherwise, again, that's the unknown that certified SC was designed to try to capture.
Okay, let's talk about that IC agreement, because we have 3 or 4 questions about that agreement. Excuse me. So is it possible to get a template arbitration agreement that we could share, Russ?
Yeah, again, the arbitration provision, yeah, again, I think there is a template version in the agreement on the MSPA website. But again, I want to emphasize that is only a template. And what I cannot overemphasize the importance. You should bring that to the litigation attorney you would use to defend the company, because there are a lot of elective provisions in that. And you want to make sure that whoever defends your company will be defending it based on an arbitration agreement that contains the provisions that that person prefers. So again, there is, I think, a template version, but that is only a template version. You want to have that reviewed by your litigation attorney.
Okay. Let's see. I think that may have answered a few of our questions about the IC agreement. And we talked about outsourcing scheduling to a third-party business as a possible assistance there. So let's see. Understanding that a third party such as MSPA is good to train ICs how to do mystery shopping, but what is the best way to provide ICs with instructions for individual assignments if we cannot give direction as to what and how a mystery shop needs to be done?
Okay, now there, the question itself, I mentioned the importance of semantics in this industry. In this industry, I would never use the word instructions, and I would never use the word assignment. Instructions, again, a very coded word in this context. And secondly, assignments kind of connotes that you are assigning work to people as opposed to offering opportunities and they selecting what it is they want to do. So But having said that, again, it is not a problem, again, for a client description of the engagement to be given to the mystery shopper, because again, that's not you, that's the client. The client can describe what the client wants done. And again, we recommend that should not be co-branded with you. You don't want to have your brand on that, because then that's you telling the shopper what to do. But a client has a little more liberty to do that sort of thing. And from your business, you want to try to detach yourself from that. And if it's necessary to provide added information to a mystery shopper beyond what the client provides, all I can tell you is just be aware that there is a business risk trade-off. Okay, that business risk being, the more of that type of guidance you give a mystery shopper, you are undercutting your independent contractor defense. You may think you have to for business reasons, but just realize that when you do that, you are undercutting your independent contractor defense.
Okay. Do you have some advice on how to word, quote unquote, outcomes versus performance in providing feedback to shoppers?
Oh, yes. I mean, again, there's no problem in reviewing the deliverable. Okay, the deliverable needs to be acceptable, but what you don't want to worry about is what the shopper does in getting that deliverable. So, again, I think just deliverable is, again, you can indicate that deliverable needs to be accepted, or needs to meet the client's acceptance criteria. But keep at least the wording always focused on the deliverable, and you want to stay away from anything relating to means or methods of performance. You don't want to have things like you shall show up on time, do this, don't do that. You don't want to have anything. You want to be outcome focused solely. You don't want to include anything relating to means or methods of performance.
Okay. So a question regarding shopper termination and identifying a shopper internally as a do not use. How would you suggest we handle maintaining our database as far as shoppers we do not wish to use due to poor performance, and how to best address shoppers questioning why they are no longer finding available shops on our website?
Yeah, that's just a very difficult circumstance, and I think it really it all really depends upon the specific facts. So with this, this probably is not an appropriate question for a webinar, but if you have some specific facts, you can send an email, and we can follow up. Because they're so fact specific, there is no kind of generic response to that, I don't think.
Okay, thank you. What is your opinion about rating shoppers and whether you show them a rating or not?
Well, again, that's kind of a slippery slope. I mean, there was guidance that came out recently with respect to at least Uber under a common law test by the National Labor Relations Board. Again, different context, but it's the same test. And in that guidance, the National Labor Relations Board, the General Counsel at least, indicated that having clients kind of rate the drivers is not fatal. But the guidance also suggested that if Uber itself were to rate the drivers, that could be a problem. So that's the dilemma you're operating out of. I mean, that's pretty much directly on point guidance from them. Again, it's the same test. It's the common law test. That's the A factor. So I think just, again, I think if you think of yourself as more of a kind of a consulting firm where you're outsourcing the data gathering as opposed to operating as a broker. That was really the Uber context was like the broker model. The broker model, it's difficult. Okay, but if you're operating the other alternative we talked about, which is you're a consulting firm and you're outsourcing the data gathering, then you're the client. You're the direct kind of, in some respects, you're the service recipient in that business. So then, I mean, I think under that model, I think you would have a little more leeway in terms of, again, so long as this is outcome based. If again, you contract with a data gatherer, mystery shopper, they submit a report, and for whatever reason, again, the report, that's all that counts, the report. Not how they did it, but the report itself, the deliverable is just deficient. Then, again, you can't be expected to continue doing business with that data gatherer because the deliverable is just deficient. So with that, I don't think that would necessarily count against you, so long as it is strictly, again, based solely on the deliverable, and that's it. Just the product that's submitted is not acceptable.
Okay. Only a couple more questions have come in, Russ, but one is about client requirements and, quote unquote, instructions about telling your ICs that information. Can you loop back around to that one more time about how you convey that information about their instructions and the shops that they're performing without it seeming like a training session?
Well, if it's in the form of materials, just documents, then you can just send them out to the shopper, but just make it very clear that these are the client's project materials. These are the client objectives we're sending to you. We are just sending you the client objectives. But otherwise, again, if it's here's, I think, just fundamentally, okay, if these are very detailed instructions in terms of, we want you to do A, B, C, and D in this order, and you're micromanaging the shop, then I don't think, again, there's no way I think to couch that in which you're going to be safe. I mean, that's kind of that's a very controlling type relationship. So I think you got to figure out some different way, a different way of accomplishing those, because there's no way to. I mean, I don't think you could package that any different. You can't change the substance just by the packaging.
Okay. Any any recommendations, or is there an action plan being set up to address the classification issue for our industry as we do our day on the Hill or our flying at the federal level? However, how we're going to target our states with these specific industry carve-outs?
Well, the whole state issue, that, in my view, is more of a funding issue. I think any kind of an association, it just has to make high-level decisions in terms of the allocation of its resources. I mean, the state legislative efforts, which some associations are very much engaged in, but they are very well funded. I mean, it's a very expensive endeavor to get engaged at the state level. Now, with respect to the 3 states that Patrick described, the MSPA was able to sort of work as part of a broader coalition with other groups that just happen to be very, very well funded, and they, there were several, hired lobbyists at the state level who were working on these bills. I mean, it's a very expensive process to get this done. So if MSPA decides to become active at the state level, just be aware, it's just a very expensive effort to pursue. Because you really, in many states, you have no choice. You really have to hire a state lobbyist, and it's an expensive undertaking to get directly involved in these state efforts.
Right. And so one question that came in is about avoiding legal issues in California. Do we avoid a legal issue if in California a mystery shopper is a one-time only because the shopper is revealed so they can't do it again?
Well, I think as a practical matter, I mean, yeah, if say you contract with one independent contractor to do one engagement in California, again, just from a probability perspective, what are the odds that that's going to trigger any kind of an audit or something? Probably pretty low. I mean, unless you mistreat that one mystery shopper and then one mystery shopper files a claim. Then again, I mean, if you only have the one shopper, still it's going to be not much of an issue. I really think that just at a high level with respect to California as well as the other states that apply an ABC test, I really think the best strategy for the industry is just be very careful how you describe your business and make sure that if somebody is ever asked, you could distinguish what you do from the mystery shoppers what they do, and have your documents consistent with that, and then that'll take care of the B factor. The A factor, the common law test, that applies in virtually every jurisdiction. There's some variation, because even the ABC test is it's a common law test with some of the common law factors deemed to be mandatory factors. And then the C factor, again, I can tell you just as a practical matter, you just need to have a critical mass of the independent contractors who actually are separately established and can meet that C factor. You typically don't need to show that 100% of the mystery shoppers satisfy the C factor. So, and again, through the certified SE, we're hopeful that a lot of mystery shoppers sign up, because if they sign up, then at least, in terms of picking, potential witnesses, I mean, it enhances your ability to do so. But again, I think ultimately, I think the best strategy going forward is to try to have your company set up in such a way that if you have to, you could satisfy the ABC test. And it is doable. Other companies have done it. I think in this industry, it is a doable proposition. You say, unlike, for example, if you're in the courier industry, they pretty much, in the state of Massachusetts, the state preempted the B factor. It says preempted by a motor carrier statute, like FAA, federal statute, because on the premise that it's impossible for that type of company to satisfy the B factor. So they preempted the B factor for that industry. But I think your industry is not like that. I think in your industry, the factor is possible to be satisfied.
Okay. I think that is probably the best way to wrap up. We do have a few more questions, but I believe they are specific with companies who are currently going through things with the state of California and some individual things. So I'm going to get those questions to Russ and to Paul and give them the opportunity to answer those, and then we can get those back to everybody. Russ and Patrick, thank you so much for your presentation today. We really appreciate it. Paul, I'm going to turn it back over to you for some final words.
Yeah, thank you everybody for participating. Just to let you know, we are working on the state level and cooperating with other associations when possible. We haven't had the resources to really move forward with that on a state-by-state basis, but we do cooperate with other associations. We're also really looking, as I said at the beginning of the presentation, there are laws within the U.S. Congress right now, both in the Senate and in the House, that are trying to do much the same with the ABC laws they're doing out in California. So your support on this and attendance to fly-ins is greatly appreciated and actually quite wise, just for protecting the industry and your companies. But again, thank you everybody for participating and your interest. And again, if you have any questions, things along those lines, you can get those through to us through Sarah. Thanks everybody and have a good day.